Another question that I'm commonly asked as a real estate attorney is what happens to my anti-deficiency protection if I choose to do a short sale instead of allowing the property to go to foreclosure. Until January 1st of 2011, there was some uncertainty in California as to what would occur if the borrower did a short sale instead of allowing it to go to foreclosure, because a number of lenders were putting language in their short sale documents that gave them the right to pursue the borrower after the short sale. And there's a question of whether that even constituted a legal short sale. Many attorneys were advising their clients not to enter into a short sale under those terms. And in those situations, many homeowners actually allowed the house to go to foreclosure rather than to do a short sale. Most of us really felt it was doubtful that the lender would succeed in court if they ever tried to collect that deficiency after a short sale. But some homeowners just did not want that possibility looming over their head. In September of 2010, that question was put to rest when Governor Schwarzenegger signed into law. At that time it was SB 931, and now it's Code of Civil Procedure Section 580E. What that section provides is that as long as the homeowner is not guilty of waste or fraud with respect to the way the property is handled, and that it's a rather ambiguous statute at this point, and the courts have not interpreted it extensively, but generally what that meant is in the home ownership process or in the process of the short sale, and it could possibly be interpreted to say at the time the original loan was taken out, but if the homeowner has not been guilty of fraud or waste and a short sale is approved by the holder of the first note, then the holder of the first note gives up the right to pursue a deficiency. In some instances, what some lenders were actually doing, even when the property was purchase money loaned, so that even if it had gone to foreclosure, no deficiency could have been obtained, some lenders were inserting that language and trying to create a possible liability for the borrower, even where none even existed originally. And the new statute puts to rest that possibility. One of the things the new statute doesn't require is that the property be purchase money loan. In fact, the author specifically said, we want some protection for people who don't have a purchase money loan. So anyone who chooses to do a short sale after that date, with respect to the first, the lender is barred from trying to recover a deficiency after the short sale. Now bear in mind that it does not affect the second. If there's a second on the property, the second can still attempt to recover a deficiency, though at this point there is legislation that is being promoted to also make this binding on the second.